Um, Hello, I'd like to start by reading out a statement to the court. This hearing is in the matter of case CFI 070-2018 before the Judge Roger Giles and is being held by way of video conference. Any orders or directions made during or after the course of this hearing will be issued by their registry in Dubai on the judge's instructions. The claimant is represented by Al-Tamimi and Company. Lead counsel is Sharif Shifji. The defendants are represented by Anoma FZE. Lead counsel is Faisal Osman. Thank you.
Thank you, Shala. Well, gentlemen, I've read the documents that were sent, and commendably, there seems to have been continuing discussion. So, Mr. Shifji, perhaps I could ask if you could let me know where we presently are.
I'm grateful, Your Honour. So there are two large topics between the parties. One is in relation to the defendant's production. There is still, regrettably, a substantial amount of disagreement. But as regards my client's production and the defendant's request to produce, there's been a very substantial amount of progress, and there are a small number of outstanding issues on keyword searches and the particular searches to be used. It may well be that it is simply not worth troubling Your Honour with those points. We'll hear from my learned friend in due course about those. But in our submission, they're points which really ought to be capable of agreement between the parties. But if I may, Your Honour, I'd like to start by taking you through the issues with the defendant's production and the claimant's request to produce, because that really, in our submission, ought to be the focus of this hearing. And when I've explained to Your Honour those issues, then I can also address Your Honour on where we are on my client's production.
Right, well, by all means, but bear in mind that it's really not going to be practicable for me to get down to a lot of the nitty-gritty of the particularly if there's some disagreement between you about the width of the request. And if in fact the request is high, then I'm not going to be the broker who brokers a lesser request. We'll have to sort it out ourselves. So I regard today as an occasion for sorting out any matters of principle. So bearing that in mind, Mr. Osman, I think that's probably the best course. I'll ask Mr. Shifji to go ahead.
Sorry, Your Honour, just on that, I think we're both agreed on that point, and certainly that's the way that we've approached our submissions for the hearing. And if Your Honour is agreed on that, then it makes sense for me to go first to present my complaint in relation to the defendant's production.
Well, yes, but if there is a question of principle in relation to the claimant's production, I don't want that to be left up in the air. It's an occasion for resolving that too. It needs to be done.
Your Honour, maybe I can just touch upon that for a moment, just so we can deal with it and put it to one side. I agree with my learned friend in relation to the claimant's production. We're just about there. We're now talking about keywords, and I don't seek to trouble Your Honour about what keywords should be applied. I would hope some sensible discussion between the parties, we can get there.
All right. Well, on that basis, unless there's any more that Mr. Shifji wants to say, I'm content to leave that and to leave it to your good sense in sorting out an arrangement for that.
Thank you.
All right. Well, we're halfway there in a kind of sense.
Yes, that's right, Your Honour. In terms of where Your Honour started with this, we agree that the purpose of today is for Your Honour to resolve the big issues between the parties, and the small granular issues are matters that really ought to be resolved between the parties in discussions. So our presentation today is focused on those big issues, and there are regrettably some very serious issues that we ask the court to address.
Yeah, it's unfortunate that my request for agreed issues seems to have fallen by the wayside. That's what I was hoping we might have. However, let us press on.
I'm grateful, Your Honour. Your Honour, it's helpful if we start by just examining in very brief overview what this case is about, because in our submission it will help Your Honour understand really where the heart of the dispute lies. My client is a DIFC registered bank regulated by the DFSA. My learned friend Mr. Osman's clients are members of the Delma Group companies and the owners, certain of the owners behind them. The sixth defendant, Ahmed, is the father of the seventh and eighth defendants, Sharifa and Maryam. And much of the chronology that you will hear today concerns those family members. So that's Ahmed, the father, Maryam and Sharifa, the daughters, and another daughter called Alanud, who's also owner of one of the defendant companies. In short, in this action, IDBI, my client, claims a recovery of a loan made to the first defendant in relation to which the other defendants gave indemnities. Those monies were advanced in 2016. It's common ground that they were advanced, and it's common ground that the loan was already in arrears by 2017 and that there's been no repayment. The full amount of the loan and the interest remains outstanding. Although the defendants initially denied it, it's now common ground that there were discussions between the claimant and Ahmed in mid-2017, where Ahmed acknowledged the debt and made various promises to pay. There was no suggestion by the defendants at that point that there was any fraud, but no payments were made. In 2018, the claimant started proceedings, and in 2019, the claimant obtained judgment in default. In 2020, sometime after, the defendants applied to set aside that default judgment, and when they did so, they raised for the first time a defence that they had been the victim of fraud by their previously loyal employees. And there were two limbs, essentially, very broadly, to their case. The first is that an unspecified person has forged Ahmed, Sharifa and Maryam's signatures on the facility documentation and the indemnities without their authorization. And secondly, they go further and they say that they had no knowledge or awareness at any material time of the facilities or the indemnities given or the money advanced. So they say that they knew nothing about any of this at any material time. The defendants also say that this case is an instance of a wider fraudulent scheme that was perpetrated on them by their employees, and it's led them to making various criminal complaints against those employees in the Abu Dhabi courts. The defendants have reported 5 of their former members of staff to the Abu Dhabi police and pushed for their prosecution. The status of those cases is currently unclear, but for one of those employees, Mr. Haider, who was the defendant's CEO, they say they have obtained a travel ban against him and that he was put in prison for a year for breaching that travel ban. And as we understand it, they now say that he has subsequently absconded along with the CFO, Mr. Mohanan, and the defendant's case is that he's in hiding. We'll come back to him because he appears on a repeated occasion throughout the chronology. The 3 brief points I wanted to make to Your Honour about the defence. The first is that it's important to remember that it's common ground that my client acted honestly throughout this period. There is no suggestion that my client was involved in any fraud. The second point is that if the defendants are correct in their defence that it relieves them of liability, then it is my client that is the victim of a fraud, having been deceived into advancing money. And then the third point is if the defendants are incorrect in their defence, and they did sign or authorise someone to sign these transactional documents, then they are effectively advancing a dishonest and fraudulent defence. And again, in that scenario, my client is the victim of dishonest conduct. So in our submission on any permutation, this is a case where my client is a victim of seriously dishonest conduct. And we say that has 2 relevant consequences. The first is that this court takes cases of fraud very seriously, and it has been repeatedly shown by this court that it will use its powers to aid victims of fraud, and that those powers have teeth. And the second is that this court recognises that when making public findings of fraud, they will have serious implications for the persons involved, and those findings won't be made lightly. Now, that's very important when we come to examine the dearth of documents in this case, because it's the defendants who are accusing their former staff members of fraud, including, as I mentioned a moment ago, their former CFO, Mr. Mohanan. And although they say that Mr. Mohanan is in hiding, in fact, doesn't appear to be the case. He's a CEO of a high-profile bank in India. He's regulated, or that institution is regulated by India's financial services regulator. One can imagine all the checks and balances that one needs to go through to get a position like that. And of course, this court will want to be cautious and meticulous before making a finding of fraud against an individual like that, and certainly would not want to do so without a sound evidential basis. And it's that lack of a sound evidential basis which gives rise to the document production issues in this case. And turning to those issues, this hearing was listed at the request of my client because there have been serious failings in the defendant's document production in response to my client's request to produce. Those failings are matters which it submitted require court intervention. And the purpose of this hearing is not to craft item by item granular searches. Instead, we're asking the court to deal with the big problems and then ask the parties to go off to agree the smaller issues. Now, my client does make serious complaints against the defendants in relation to the way that they've behaved and performed their Part 28 duties. And in particular, the process, and it's an ongoing one, has revealed a number of areas where we say the defendants have failed to be frank with the court. Now, I accept that that is an unusual and a very important and serious allegation. It's not one lightly made. And in cases like this, where allegations are made, they're normally responded to with evidence from the party explaining exactly what they've done and explaining the discrepancies. We've not had any of that from the defendants in this case. They filed no evidence at all on these document production issues. And instead, what we've had is a series of pretty unsatisfactory letters raised in correspondence over the last few days, including material documents disclosed late last night, which the defendants previously said didn't exist, and letters this morning on new important matters. Now, none of that, we say, is an appropriate way to litigate a case like this, especially where the defendants are asking the court to make findings of fraud against a number of individuals. Now, our other material complaint is that we say that the defendants' legal representatives have not been adequately involved in the document production process. We make no criticism of the lawyers personally, but we say it's a fundamental part of Part 28 that where a party is represented, the lawyers have to be involved in the process to make sure it operates honestly and fairly. And if that had happened, then one hopes we wouldn't have had the issues that we're now encountering with a lack of frankness to the court. Now, in a moment, Your Honour, I'll take you through the big picture issues on the document production, but it's necessary just to say a few more words about the factual context for this dispute. In particular, there are 2 points I'd like Your Honour to bear in mind when we consider the dearth of documents. The first is that the Delma Group was a substantial and serious enterprise during the relevant period. There's no dispute about that, or indeed about the following points. The Delma Group had numerous substantial contracts across the region, and they were in all manner of different manufacturing and construction and contracting activities. One of the defendant companies is a company called Delma Engineering. That was a major road builder. It alone was said to have an order book of $450 million. It employed a substantial finance team. You've heard about the CEO, the CFO. There were 20 internal accountants. And on top of that, the group had at least 2 auditors that we know of, Ernst & Young and another company called FRG Global. In addition to that, there were other external accountants who were involved in the defendant's affairs. The Delma Group also had its own internal IT department and an internal audit department, and there's no dispute about any of that. That's my first point. And then my second point is to say something about the defendant's involvement in the business. Sorry, the sixth to eighth defendant's involvement in the business. Now, as I said, there are four key characters from the defendant's family involved in this matter, and three of them are defendants. That's Ahmed, Mariam, and Sharifa. The defendant's defence is that they were not involved in the Delma Group's day-to-day management or operation. And I'd be grateful if Your Honour could turn that document up. The defence appears in the main bundle at tab A and then tab 3. Does Your Honour have a copy of that?
I have printed hard copies of various key documents, and I can turn up the defence very easily. What paragraph am I looking for?
We're looking for paragraph 16.2, which appears at page 29.
I have that.
I'm grateful. And it's 16.2 that I wanted to focus on. Mariam, Ahmed, and Sharifa were not involved in the Delma Group's day-to-day management or operation. So that is their pleaded case. If Your Honour now would kindly go to a document later in that same bundle under tab E, tab 20, and then we're looking for page 308.
Yes.
This is an email from an individual called Mr. Sidar Appiah, and it was sent to us in late 2015, which is really in the centre of the relevant period. And it was enclosed information about the 6 to 8 defendants. Now, it's the defendant's case that Mr. Appiah was an honest man. He's not one of the fraudsters that they say worked within their organisation. In fact, they called him as a witness in this action on another distinct matter. So their position is that he is loyal and honest. And in 2015, he sent us a profile of the defendants. And if Your Lordship, Your Honour turns to page 310, 2 pages later, there is a profile that he sent us of Mariam, the 8th defendant. And that profile explains that she was 34 at the time, that she'd been educated. She had a Bachelor's of Science from a university which is in New York, which, as we understand it, she attended in New York in business administration. And then it goes on to say her business activities, that she was involved in the day-to-day affairs of the following companies. And those companies are the third defendant, that's the first one, the first defendant, then the 5th defendant, and the rest of the Delma Group. So we say this is good contemporaneous evidence from someone the defendant says is honest, that the 8th defendant was involved on a day-to-day basis in all of the material companies relevant to this dispute. Now, interestingly, when we come to my learned friend's skeleton argument for this hearing, the idea that the 8th defendant was not involved on a day-to-day basis seems to no longer be pursued. And he pursues a separate point in relation to the 6th defendant. And if Your Honour would kindly turn that up, it's paragraph 16 of his skeleton argument.
Yep.
And he says at the beginning of paragraph 16, Ahmed, so that's the sixth defendant, is the controller of Delma Emirates Group. He was not involved in its day-to-day management. So the allegation there now seems to be narrowed to the sixth defendant. But that point is contradicted by the sixth defendant's own evidence that he filed in support of the application to set aside default judgment. And I'd like Your Honour to turn up his witness statement, which is in bundle HB1. Don't know if Your Honour has that one. It's not the main application bundle, it's another bundle.
That's going to take me quite a while to get to. Just read out the relevant part to me.
Of course. So this is this is Ahmed's second witness statement filed in support of the default judgment application, and it's paragraphs 10 and 11. I'll just read those to Your Honour. I just explained by background, he's dealing here with the question of whether he signed one of the documents. He says, the allegation that I met the then Chief Executive Officer of IDBI, Mr. Virender Sikhanaya, on or around the 10th of December 2015, and that after that meeting I agreed to provide the accepted sanction letter is not particularised nor supported by any evidence. For the avoidance of doubt, I did not meet with Mr. Sikhanaya, nor did I execute or provide an executed sanction letter. He then goes on, this is the key part. I note that in my capacity as founder and principal shareholder of Delma Group, I was attending meetings with bankers and other professionals on an almost daily basis to discuss business. Although I do not remember a meeting with representatives of IDBI before the 31st of May to discuss a potential relationship, I cannot exclude that such a meeting took place. So just to repeat, his evidence there is that he was attending meetings with bankers and other professionals on an almost daily basis to discuss business. And that was obviously the business affairs of the Delma Group, as he says. So in light of that evidence from the defendants themselves, it's obvious that the sixth defendant was involved on a daily basis, at least with meeting with the Delma Group's financiers and trying to arrange financing in the key period. And so on the basis of that material, we say that both the sixth defendants, Ahmed, and the eighth defendants, Mariam, were heavily involved in the Delma Group business on a day-to-day basis. And they were also in regular contact with each other, and we'll come to see their evidence about that. Now, those points are important when Your Honour comes to note that there is not one single document that has been produced that shows either the defendants' contact with each other during the relevant period or their contact with anyone at the business. And that's because the repeated refrain that we've had is that the defendants weren't involved in the business at the time. And we say that's demonstrably wrong. And in fact, it's just a reflection of the defendants not having carried out proper searches. So having taken you through that factual context.
A side excursion, what's the current status of the corporate defendants? And I include in that the company Delma Emirates General Transport, whose status to me is not clear, whether it's corporate or what. Are they all still functioning and under the control of the family?
That is, we just don't have the information, Your Honour, to answer that. All I'd say is that they were very substantial businesses, and substantial businesses like that don't tend to disappear entirely. They haven't gone into any sort of liquidation process.
That's right.
As far as we're aware.
Surely the bank would know if they've gone into liquidation or into receivership. Mr. Osmond, can you perhaps help us so I know where they are?
I don't have the actual position as to their entire financial health. They are, we say, in severe difficulties, and I don't understand that they are insolvency or in liquidation, however.
Right. The point of my inquiry was that when we get to the question of what orders might be appropriately made, it strikes me, subject to what you gentlemen might say to me, that each of those companies needs to respond separately to the request, together with the personal defendant responding separately to the request for documents. And that's why I wanted to know whether they were still extant. We'll come to that. I should put that on the table.
Thank you.
Your Honour, I'm grateful. That is helpful, and we would endorse that. So, Your Honour, perhaps if I may, I'll then turn to the ways in which the document production process is broken down. By way of introduction, in the defendant's application to set aside default judgment, they made a great play of the extent of the fraud that they had been subjected to and the weight of documentary evidence to back up that fraud. And as you might expect, they pressed that point very hard in trying to persuade the court to set aside default judgment, which the court did. And we'll see some of those references in due course. But in that context, it's surprising that in the defendant's standard production of documents under RDC 28.15, that is to say, the production of documents that they wish to rely on positively in this action in support of this case, they produce no contemporaneous documents at all, not a single one. And in contrast, the claimants produced over 1,400 pages of material. And since then, it's been, frankly, a war of attrition to try and get any documents out of the defendants, and their production has been piecemeal and selective, and they have regrettably made inaccurate statements to the court on a number of key issues. Now, there are three main topic areas that I wanted to address Your Honour on. The first is what are called the internal investigation documents. And I've got 4 points to make on the internal investigation documents, and then I'll take Your Honour into some of the detail. So those 4 points are, firstly, we know that there was an internal investigation into this alleged fraud in 2017. The second is that the internal investigation is important because it took place in 2017. That date is important because that's a point by which the defendants knew, the SIC defendant knew of our claim, but it was some 3 years before a defence of fraud was raised to this claim. So that's my second point. My third point is that the defendants have raised no objection to the production of these documents. And the fourth is that their response, in fact, when producing documents, has been a classic piece of obfuscation. And they have instead produced a 2018 external report that they relied on in support of some litigation that they were pursuing. So we don't have the internal investigation documents. We have a quite different external report that they relied on to pursue a case. And obviously with external reports, one puts one's best foot forward. So an external report in support of a case wouldn't be expected to contain adverse material. So those are my 4 points, and I just want to develop them a bit more. The first is on the existence of the internal investigation. We can pick that up by looking back at my learned friend's defence, which we were looking at a moment ago. That was in Bund.
I've seen a number of references to that. There doesn't seem to be any dispute that it is said that there was a significant internal investigation. Is there any dispute about that, Mr. Osmond? Is there any dispute that there was?
Sorry, I was just turning on my microphone. There was work done internally with the remaining staff who were there, who tried to pull out as much documentation as possible. And that documentation, my learned friend is correct, found its way into a report, which was the first substantive complaint that was sent to the police. And there's other material that emanated by the authorities later on, which I will deal with in due course.
Well, I don't think we need to get into the nitty-gritty.
No.
It seems to me that there was an internal investigation.
There was an internal process, yes.
Right. So documents must have been created in the course of that.
Documents, what we say in relation to that is that all of the documents that were obtained were then placed and put towards that report, which was sent to the police. But the short answer to your question is that yes, the documentation was pulled out and compiled.
Documents were obtained in the sense of pulled out, collated, and there must have been a report of some kind. They weren't just put in a file. Someone went through them and said, this is the result. That must be
there wasn't a formal report in the sense of an internal formal report. It was more of a case of the material being put together and collated. It wasn't as organised as one would hope it would be. It was just more a case of trying to find out what had happened.
I don't get how organised it was. We're looking at the principle here. Someone must have said something, even if it was a 2-line saying, these are the documents that show we were defrauded, or something like that. Or it might have been a 50-page document describing it in detail. But whatever it is, there must have been something. Can we not get to doors on that? All right. Now, Mr. Shivji says there is that kind of material. Now, let's move on once we've established that.
I'm grateful, Your Honour. Now that I would only take Your Honour to the detail, but that investigation involved Delma's IT officers and their finance officers, and that's important because in due course, Your Honour will come to note that there are many of the key emails which are missing, and the finance documents were missing, and we got one late last night. But I'll come back to that. So it was obviously a wide-ranging investigation involving all the people you would expect, and this is a big organisation, so you would expect it to be done properly.
Can I just use this to try and set the parameters of what we're about now? Mr. Osman, I think you've disappeared for a moment. Are you with us fully?
Yeah.
Thank you. If I were to accept as it would be fairly plain that I'm prepared to do, that there must have been documents of that kind, then it seems to be accepted that whatever they are, whatever there is of that kind, and it might be the collation with 2 lines, or it might be also a 50-page report, I don't know, but whatever it is, that needs to be produced. Is there any dispute about that?
Can I spend 1 or 2 minutes? I'm sorry to interrupt my learned friend's flow, but I think it's probably important just to explain.
I think we need to work out just my present view is that if there is that, and as I understand it, it's not disputed that that is relevant and should be produced, then it should be produced. The only question then is what machinery one goes through to make sure that the defendants comply with their obligation to produce it. So, yes, Mr. Osman.
Yes, it's that part, Your Honour. The number one, there was no formal internal report, and I think we're there on that. Number two, what is still there in the company which would be able to be searched in order to obtain all of this relevant material, including material which was generated at the time for the purposes of getting that internal understanding of the fraud that took place. And what we have done, and I'll explain this in due course in further detail, is that we've located all of the digital devices. There's a difference between digital and hard copy, and I make that our distinction between the two, starting with digital. We've located all of the available digital devices that there are, and what we have done is we've approached it on the basis of determining which custodians should be examined, the custodians of digital devices, and then applying keywords. And the process that we've taken is A, custodian, B, keywords, and have run that process through all of our digital material. And one of the things that I was going to suggest, and respectfully appears to be a sensible way to proceed, is to re-look at all of those custodians and to re-look at the keywords and determine whether the custodians list needs to be broadened and the keywords need to be broadened as well. And as I've hopefully said in my skeleton icon, and I was going to say here, we are happy to cooperate with broadening that list of custodians and broadening that list of keywords. And what we will also do as well is give a list of all the digital sources that are available for those exercises to be done. And in my submission, what that will do, if we get the custodians right, and if we get the keywords right, is to capture the data that needs to be captured. And that, may I suggest, is the most robust and efficient way of proceeding. So when it comes to finding what documents were being generated, done, or pulled out at that time, the custodian in the keyword process should be responsive to, or the documents responsive to those two fields should give rise to that information. And that's the approach which I've suggested in the skeleton argument, which I suggest is a practical way of dealing with the matter now.
Do not the rules require you, in your immediate response under Rule, I think it's 20, to explain the document retention policy? Sorry, yeah, go ahead. Is that agreed?
I think there's been a slight misunderstanding, I accept, in terms of what that document retention policy actually means. There's the document retention policy that was in place on a corporate basis before effectively all of this took place. And I think that's something which has been addressed and we've spoken about. The short answer to that is that there was no formal corporate retention policy. In terms of what the retention policy is from the point of this exercise and what policy has been put in place in order to retain various documentation, that is something which we can put together and which we can do.
Document retention policy does not mean some formal policy written out to say these documents shall be kept for 99 years just in case we have litigation. What that requires is an explanation of how documents were organised. And that would disclose the digital sources. It would also explain whether or not there were hard copies kept, because I would not immediately assume that these companies carried on business without any paper at all. And it would explain exactly where these things might be, or to be more correct, would enable the explainant to see where these documents might be. From that, there could be a sensible attempt to work out a search process, whether it be by keywords or, in case of paper documents, someone having to actually go through them if necessary.
I can absolutely see the value, and I can see the sense in explaining first a list of what digital sources there are, explaining that. Secondly, providing an explanation as to, if I can put it this way, the hard copy universe at the various companies. What is left? We say the company is in elements of disarray, but we can explain what is left, give the current picture, and give the current digital picture as well. So I see that point, and I hope I've recognised it in my written document as well. That appears, I accept, to be a good start. Explain what that universe of written and digital material is, and then again explain, as we have, what custodians have already been applied, work together to determine whether the custodians could be expanded, explain, as we have, what keywords have been applied, and work together to see what keywords can be expanded as well. Again, I'm trying to get a grip of moving forward, which is hopefully what I've attempted to do in my written document. It's a long answer, but that's where we are.
It's not just a move forward, although it may end up that way, but it's something that should be done originally. Rule 20 required it. Did it not?
I have to. I can see the value, and the value was originally there of doing this more definitive explanation of where the material is.
That's the whole point of that part of Rule 20, isn't it, Mr. Watson? That you don't have the responding party simply saying, I have searched and these are the documents that I've got, full stop. He tells the requesting party, this is how my documents are organised, that's my retention policy, and this is how I have searched those documents, and this is the result. That lets the requesting party decide whether or not it's happy with what has happened. Isn't that the sense of the rule?
I disagree with the idea that we haven't given any explanation at all. In the DPS documents, what we have said is that we've given explanation of what digital sources are still available. We've explained that there are various backup sources that are still available, that some of the computers are no longer there. We've explained that we've gone back to the original email service providers, Etisalat, and there's another provider as well, to see if we can source the documentation, the digital email information from those sources as well. That has been unsuccessful. So there has been explanations given as to where we are with the digital sources as well. So I respectfully push back against the idea that we've done nothing at all in that respect. We have tried to give an explanation as to what the universe of digital information is. I can see the value. I readily accept that, of now putting down on paper precisely what those digital sources are and defining what those universal documents is. And I can see the value in having done that to then say, these are the custodians that have been applied and these are the keywords that have been applied, which again, we have explained. But for the purposes of saying, are there other custodians which we can search? Are there other keywords which we can apply as well? And that's what I hope we can work together with to try and find the right triggers to obtain documentation as responsive to those reasonable and sensible requests. Right. I say all this that there is a broader point as to whether, in fact, and I hear what Your Honour says in relation to, look, there must have been an internal process, whether you call it an investigation or a run through of what material was there as to what happened at the time. I accept that. But I would wish to add, it's important, what actually has been produced on the issue of whether there was a fraud at the Delma Group, and whether what has been produced is sufficient to the issue of whether there has been a fraud at all. And what we say about that is that there has been a very substantial amount of information which has been produced, generated by numerous prosecution agencies, which demonstrate that there was a fraud that took place at this organisation. So I would want to address you on the context of what we have already, what further information can be obtained from those authorities, which would go to the heart of the point as to whether there was a fraud. And what I say in relation to...
Ms. Roth, there is no point in that. Mr. Shibdi is not content with the extent of production. If he is right, it doesn't matter if you explain how terrific the stuff that you produced is, if he's correct that there is likely to be more. If there is likely to be more which has not been properly been produced because there has not been proper attention given to it, then he's entitled to relief. This is why I'm trying to get to the nitty-gritty of what is required of me. The ultimate thing required of me is whether I make some order that requires something more to be done. More. That doesn't involve saying, yes, you produced something. This is why I'm trying to get to the nitty-gritty of what I am being asked to decide.
Yes, can I do? And again, I'm forgive me for trespassing all over my learned friend's points, but I think the issue of what more is required is the essential question. And the reason I say that is because cutting right to what we're trying to do is we're trying to deal with the issue of whether there was a fraud at this group. And so what we have done is that we have, what we say, given over the best evidence possible as to whether there was a fraud of this group. And the best evidence possible as to whether there's a fraud of this group is to give over the results of numerous prosecutions, and that includes depositions, that includes arrest warrants, that includes the process that those authorities have gone through to look at whether there has been a fraud of these organizations, and look at the companies that will pay these monies and look at the individuals concerned. So responsive to the issue as to whether there has been a fraud, we say we've produced a huge amount of material, and if necessary, there's up to 50,000 pages worth of prosecution material that can be given as well. But in order to keep proportion as to dealing with the issue as to whether there was a fraud in this company, that's what we have given material about, which was responsive to that issue. My reaction to whether we need to actually then go back to Delma Group to effectively do that work, which the police and prosecution authorities have already done and are continuing to do, the process of that is, as I say, that it is to identify what's left and to identify the responsive keywords and to run them again. And that will generate the material which we say is still in our possession. So I think there is a need to really get a grip of what the issue is. Has there been a fraud? And look at the material which is on the table. And that's been a serious amount. That's been a very substantial amount of material from all of those agencies. So when it comes to your honour,
as a matter of principle, Mr. Osborne, you are wrong. You don't pluck out and say this is the best evidence of what happened and produce a report of the investigating police. The request is for the documents within the possession and control of the party. That's what your obligation is to produce.
I understand that.
The contemporaneous key documents. That's the starting point. If there is going to be excess and you say we don't have to go further, then what you may not have to go further and produce is what the prosecuting authorities say. That might become excessive. Your obligation is to produce the original contemporaneous documents, including
I understand.
its own investigation.
Yes.
Now, does that help matter of principle?
I understand your Honour's point. As I say, the way in which we need to do that is and the only way we can do it is to look at what sources are available and to apply those keywords. I can't give any other suggestion than that. That is what the best way of searching for these documents. Well,
it may be that as a matter of principle, we've got somewhere on this that this will have to be done again, and the detail of it, the parties can have a go at working out, and I hope that they do, because it's not something that I'm going to do here. Now, thank you, Mr. Osborne, for the help. It has been helpful, I hope, to have this discussion with Mr. Osborne, even though it's out of place. Perhaps we should seriously.
It is. Can I make 2 points? Because I think it might help my learned friend. And again, I know how irritating it is when someone right in the middle of your submissions, but I hope what I'm trying to do is of assistance. There are 2 points I would seek to make. The first is this: there are a lot of documents already produced which are in Arabic, and that information, when properly looked at, should assist in relation to a proper understanding of the issue of whether a fraud existed. I think that is important to recognise. I hear what your Honour says in relation to obligations, and your Honour would have noticed that my reaction to that. But in terms of understanding the issue of what took place and the fraud, there is a lot of material there, and we do need to look at that. And I have made what I think is a sensible suggestion in my document, that the parties can get together and get a grip of that material to understand what has taken place, what the investigation is, and whether there is sufficient information to understand whether fraud has existed. So I do extend that invitation still. Secondly, in relation to the material that we have.
Well, I'm going to interrupt because, again, may I suggest you are off course. The purpose of this exercise is not, quote, to understand what happened, unquote. The purpose is to produce documents. If they help the claimant understand what happened, well and good. They may not do so. The purpose is to produce documents, full stop.
Yes.
Understand?
No, I do understand. I understand, and my point really is in terms of moving the matter forward in terms of giving that understanding. I'm just trying to be practical in that respect, but I don't push back against the need to do that aspect of the work. I don't.
Now, I interrupted. You were going to make a second point.
Just in relation to what material will be obtained from that keyword search, and again, and this is not an attempt to duck the need to do that keyword search or that custodian run through, but we don't expect to have much more material than has been put together and ultimately found its way into the report, which was put before the police. So The reason I raise that is because once that is done, and it is done, then we then have to look again on the issue of proportionality as to really what more we need to do.
All right. Well, back to Mr. Shifty. I think, Mr. Shifty, I rather hijacked things, but I regard this as an exercise in achieving a result rather than necessarily following the usual steps of one party and then the other party and so on. Back to you.
And of course, Your Honour, and it's very helpful the way Your Honour's approaching it. And we, just going back to Your Honour's fundamental point, the purpose of this exercise at this stage is to understand the universe of material. Your Honour is absolutely right about that. That is what we've been pushing for in correspondence throughout. That until now, the defendants have been resisting that. And the first sense that one got that they were going to make any concessions was my learned friend's skeleton argument. Your Honour is absolutely right that they ought to have provided that material pursuant to their 2820 obligations, and that should have happened on the 8th of September. So it is long overdue. And Your Honour is also right that once we understand the universe of electronic and hard copy documents, then we can approach the question of searching. And that is all that we are looking to get out of this hearing. Essentially, is an order compelling the defendants and their legal representatives to give evidence on what the universe is, and we'd like that, as I said, supported by a statement from the legal representatives so that we know that we can rely on it. And once we have that information, we can decide what the appropriate searches are. Now, my learned friend keeps on getting drawn into talking about keyword searches, and then he goes on to say that those searches won't reveal any more material or much more material. No one knows about that at the moment. There's no evidence from the defendants on any of this. And I think I'd ask my learned friend when he makes his submissions to identify the areas where he's making submissions which are not supported by evidence, because I think it might be helpful for Your Honour to understand the areas where the defendants are getting a bit off-piste. But at the moment, we've got no evidence, no proper evidence on what they were obliged to provide under 2820 to understand the universe. And until we have that, we can't know what the searches are. But it doesn't sound like it's going to be that onerous, because his position is there isn't much more material. So anyway, Your Honour has the point. I think Your Honour's intervention was very helpful, and it's certainly shortcut matters because it's cut right to what I'm asking for in this hearing. Now, I was addressing all the internal investigation. I probably not necessary to say much more about that because Your Honour, I think, has cut to the chase. But I'll just make one point for Your Honour's information. That investigation ought to have also traced what happened to the money, because you get the impression from the defendant's defence that all the money went to third parties and they now say all these transactions were fictitious. But 1.8 million of the facility went directly to one of the companies that are owned by the 6 to 8 defendants or their daughters or the other daughter. So it went to one of their businesses, and they quite conveniently forget that, and we don't have any material that explains what happened to that money. And we will want that, but I'm not asking Your Honour to make a specific order at the moment on that. If we get information about the universe of documents, then that will be enough to get us on the road to what we need to do. And as Your Honour said, then the parties really ought to be able to try and agree the searches and only need to come back to the court if there's a roadblock. So Your Honour, if I may, I might move on from that topic, internal investigation, to a second topic, which is the financial statements. And I can deal with this point pretty quickly because I think it fits in with Your Honour's previous point. I explained that the 2017 investigation included the finance officers. That obviously would have involved looking through the financial records. As part of our requests, we asked for the audited financial statements for the first defendant and the other businesses. And I'd just like to show Your Honour that request. Sorry, I'll just grab my file. This is this is in B9, the main application bundle, B tab 9. and it's the first request. It's request 1. Does you want to have that on page 131?
Nearly. So got that now.
I'm grateful. So it's request 1. Your Honour doesn't need to read all of it, but just for Your Honour to note that this is for financial reports, records, emails, etc., relating to financial standing or alleged financial difficulties within the group, including without limitation audited accounts, financial reports of auditors, management accounts. Does Your Honour have that?
Mm-hmm.
And then if Your Honour looks at the objection, the defendants, the first point they make is one of relevance. Now, I don't agree with that, but I don't need to trouble Your Honour with that. It's obvious that this material is relevant. It's the second paragraph I wanted Your Honour to have a look at, which says, furthermore.
Yeah.
And if you could, Your Honour, just read that paragraph, please.
Yeah.
So the response that they were giving in answer to this material is that they said since late 2015, they hadn't produced any management accounts or audited accounts, and that this statement they haven't withdrawn yet, but it's wrong, and it's important for Your Honour to understand this, because this is a serious failure on their part. So last night, after a train of correspondence where there was a little chink that we saw about this point, we wrote a letter saying it does seem like you're referring to some other audited statements. And then last night they produced the audited accounts for the first defendant from July 2016. And that's a final audit report signed off by the auditors with a director's report from Mariam and Sharifa. And in that director's report, there are all the accompanying accounts, and there's a list of personal guarantees and facilities entered by the company and guaranteed by Mariam, Sharifa, and Ahmed and others. Now, those accounts are for the year ending December 2015. That financial period predates this facility, but in the intervening period between the facility being entered, between the accounts being closed and the accounts being signed off, the facility was entered. And so that one would expect that the facility would have been looked at by both the directors and the auditors as part of the audit process, because as part of the audit process, you need to look at post-balance sheet events up to the time that the accounts are finalised. So anyway, this highly material documentation, according to the defendant's submissions to the court, this does not exist. And this is one of a number of areas where the defendants have regrettably given inaccurate information to the court. And so when we come to the end of this hearing and I ask Your Honour to make an order, we will be asking for an order by someone who the court can then rely on, which is why we'd like an affidavit from the legal representative, because this is not the only occasion where there has been a serious error in a statement to the court by the defendants as to what doesn't exist. And of course, if parties are not frank with the court about the existence of material, then key things may be overlooked. And it's only through good fortune that we have identified this error.
Can I just explore with you for the moment? I know maybe I'll just defined by an affidavit legal representative. I'll make my current thinking known to you so you can address it. And that is that while it is the professional responsibility of the party solicitor to ensure that the party understands the party's obligations in searching for disclosing, does not seem to be at the moment there is power for me to order the solicitor to do anything or require an affidavit from the solicitor. The party is the one which must, in due course, certify as the document production statement in the party understands the obligation. Underlying that is the professional obligation of these to explain and make sure the party understands. I'm not too sure there's anything more I can do. So, at some point, therefore, you'll need to expand on what you just intimated.
Well, I'm grateful. I think in fact, this is my omission because I didn't express myself very well. Your Honour's right that it's the party's obligation to perform, and ultimately, Your Honour can only make an order against the party. That Your Honour's absolutely right about that. But what we had in mind was evidence, was an order that requires them to put in their own evidence, giving information about the universe of documents, and then requiring them to produce through their legal representative, whoever that may be, a statement saying that that legal representative has made their own assessment by going into the offices, speaking to relevant people about the universe of documents, etc. Now, that is something you can require them to do. You can require them to produce a statement through their legal representatives. The obligation, of course, is on them, not on the legal representative. If they don't do it, it's the party that will be in breach, not the legal representative. But it's a way of Your Honour having some satisfaction that the job is being done properly. And in most cases, one perhaps wouldn't have too much of a worry because one would be able to trust a party to do that job properly. But regrettably, in this case, that trust is broken down. And the instance I've just shown you on the financial statement is only one instance where the information given to Your Honour is inaccurate. But there are others. There's another one I'm going to come to in a moment. And these are serious failings, we say, because if the court's not given accurate information, this process just doesn't work. So that's the way forward I was going to propose.
We'll need to come back to then what you're asking. I'm not at all sure about it, but we'll come back to it.
Okay. Well, I'm grateful for Your Honour flagging the concerns, and I will try my best to allay them or come up with a proposal that walks the path that satisfies Your Honour.
I know it's a dreadful, but even judges occasionally can't put their past at the bar behind them. And I have had experience at the bar of a party which swears blind that it does not have a document, and then what you do is you subpoena a third party, such as the auditing accountants here, and it becomes perfectly plain that they do. It's an interesting situation.
Well, I mean that's an apposite point, because that's where I was going next, which is this is the role of the defendant's auditors. So the defendants have sworn blind, as you saw from their response to our RTP, that they hadn't prepared any management accounts or audited statements after late 2015. In fact, we know in mid-2016 that they were doing that. Now, the auditors were a company called FRG Global, and there have been no documents produced of any communications with FRG Global. And my learned friend's position in his submissions is that those documents are not relevant. Now, with the greatest respect, that's not my learned friend's strongest point. It's obviously relevant what the auditors were being told, because if the auditors were told in 2016, 2017 that the companies had a liability to IDBI, then that destroys the defendant's defence that they didn't know about this facility. And one can also note that there is an army of accountants within this organisation, and the people they accuse of fraud is a small group. And it seems highly improbable that that small group would have been able to mislead the auditors. And one can see from the audit report that the auditors did what auditors do. They made a inspection of the company's books and records. They checked whether the financial information was consistent with those books. They confirmed that they had received all the information necessary for the audit. So they did a proper audit job. And we will need to see what the communications were, because one would expect that those communications would have involved this facility. And as I said, that would be very damaging to the defendant's case. Now, the defendants say that those communications are not relevant.
Supportive of this case if it turns out there was nothing.
Sorry, it may support their case, did you say?
Supportive of their case if it turns out there was nothing told to the auditors.
Yeah, it could be supportive of their case. Your Honour is absolutely right. The resistance that we're facing for the production of this material perhaps suggests that that's an optimistic way of looking at it, but time will tell. But in any event, we say that those communications are clearly relevant. FRG Global were not the only auditors. There was also Ernst & Young. There was another local firm called, let me just find my reference, called Salim Auditors. And Salim Auditors produced personal balance sheets for D6 to D8 for this transaction. And they were personal statements of the assets and liabilities of each of the individual defendants, again from July 16, which were provided for us. And obviously, one would expect those auditors to have been in contact with the individual defendants, because you need their involvement in order to get information about their finances. And again, we'll need to see those communications. We'll need to understand what the defendants thought they were doing in instructing auditors to prepare personal balance sheets in circumstances where they deny entering any sort of guarantee or being part of this transaction in any way. Now, my learned friend's position is that none of this is relevant, but it is, in our submission, it clearly is. And so when we come to ask Your Honour to make an order in relation to the universe of documents, that universe should also include identifying the company's external agents at the relevant time, because it's only by good fortune that we have found snippets in the evidence that show what these auditors were doing. And there may well have been other audit firms or accountants who were involved in part of the process that we don't know about. But we ought to know about that, because we could either get those documents then from the defendants, or if they don't have them anymore, we could approach those third parties and, if necessary, come back to this court and ask for an order against them. So, Your Honour, those are my submissions on the audited accounts. I had just one other point on FRG Global, who was one of the auditors, which is that the documents show that they also audited some of the goods which were paid for using this facility. So one of my learned friend's submissions is that all these transactions were fictitious. This was all made up. The whole thing was a dishonest scheme. But some of the payments that my client made were in response to an audit report from FRG confirming that they had physically inspected the goods in relation to the invoice that we then paid. We've only got a few references to that, but that presumably that may have been a evidence of a much wider process, that from time to time big businesses like this have audits of goods in their inventories, goods in their possession, etc. And that obviously undermines the defendant's case that these transactions were fictitious. Now, my learned friend hasn't there's no evidence on any of this. It's not a point that my learned friend has dealt with his skeleton. He filed a supplemental document just saying that this material is irrelevant. And there is a suggestion in correspondence that they are proposing to make a criminal complaint against the auditors for falsifying the accounts. Now, we don't really understand how that could work. I'm a bit sceptical as to whether it's really prompted by the right reasons. But all this shows is that on their own case, they obviously recognise this material is very damaging. And the only thing they can come up with at the moment is to say that the auditors were acting in a way that's criminally culpable. So anyway, those are my points on relevance of the audit material. I wanted to move to the sort of third topic, which I can also deal with pretty quickly, which is the contemporaneous emails. Now, the internal investigation included the IT department.
I interrupt.
Of course, yes, Your Honour, of course.
The course you've done before, who asked Mr. Osmond to respond on the second topic of audit materials, including do you still maintain there's no relevance? So why, and so
on. I heard my learned friend's suggestion that what we should do is to put together a list of auditors who were effectively involved in the business at the material time. I will take instructions on that, but I can see the force in giving that list, just identifying who those individuals are. The reason I say that I can see the force in it is because I've already made the observation that one of the things that is absolutely worthwhile doing is to have a discussion about the keywords that need to be applied. And I can see that in discussing the keywords that need to be applied, the identification of the auditors of some of those keywords has value. So I hear my learned friend's point in relation to the list, and I will take instructions, but I can see why my learned friend makes the point. So that's in.
Beyond that, do you maintain that once the auditors are identified, production of balance sheets and audited accounts and so on, if they exist, or if they really don't, the proper statement that they don't exist is something that should not be required because it is irrelevant. What is your position on relevance?
I've heard my learned friend. Our concern about the audit points is this: the person involved in assisting the auditors was one of the protagonists, we say, of the fraud that took place. That's our concern. That appears to me to be a concern that needs to be, if necessary, needs to be addressed. In terms of the relevance of the material, I can see my learned friend's point. I'll be frank about it. I can see my learned friend's point.
It did strike me as being relevant, and if behind your last remark you're thinking maybe the whatever is produced is itself part of a fraudulent scheme, which on your client's case is practiced on them, well, maybe it is, but that'll have to be sorted out at trial. It's still relevant.
Yes, I hear you, Honor, and it's not just a caveat by me. There is a real concern that the person involved in liaising with the external agencies, the auditors and accountants, was the very person who was at the heart of the fraud that was taking place. That is our concern. But as Your Honor says, that's something that, if necessary, will have to be the subject of evidence. We're dealing with relevance. I understand that. I've heard my learned friend's point. I've also heard Your Honor's point that there may be indeed material in there that would assist our defence if that appears to be, for example, there's no recognition of the IDBI facilities in any of the reports. So it could indeed cut both ways.
That's all part of relevance. So I think the point of principle here is that it seems to me that materials in that class, that request, are relevant materials. And then the question is how one deals with their production.
Can I touch upon that latter point? Forgive me, I'll cut across you. Can I just touch upon that latter point? And it goes to what I was saying first of all. What we can do at the moment is to give that list of who those individuals, who those entities were, who were carrying out that audit exercise from what we understand. And again, that should be something which can be done. And again, it will play into what will need to be searched, what keywords need to be applied. I cannot say that material sits with us. All I can say is that it can be given, the identity can be given, and we can search for it. But I don't think you want to say much more than that at the moment, unless I'm mistaken.
You are mistaken, because
forgive me.
There may be a necessity to search for keywords, for example, to find correspondence between
I agree with that.
The auditors. But it's quite plain that if audited accounts exist, someone can put their hands on them without any trouble at all, if they exist. So that sort of thing, it seems to me, would have to be subject to an order which required the defendants to put their hands on their hearts and say, if that is their position, these do not exist. That's not a keyword proposition. clear, obvious documents.
Yes, that's useful. Thank you.
Okay, now your last category, last or third, I'm not too sure.
We are making progress, Your Honour. I'm grateful for your patience. Can I do, but before we leave the accounts, I just wanted to make a few observations on my learned friend's submissions. His submissions were solely directed to the auditors. He seemed to be quite careful in the way that he expressed that, but I expressed the point more broadly. Not just auditors, it's also third-party accountants. And I explained that FRG Global also carried out this role of an inspection agent for the goods. Now, we just don't know who those third-party agencies these companies used. So we will have to draft some language to cover the relevant sorts of third parties that a company might engage, which would be relevant to this exercise.
In principle, I think they fall within the relevance category.
Can I make?
Sorry. No, I'd just like to finish my point.
Yeah,
please.
sure.
And the second point is that if those documents, Your Honour is absolutely right that we will want to see in due course communications on relevant issues. And if the defendant's position is that all those documents are no longer in their possession, then of course someone could make an approach to those third-party agents for records. And for audit firms, accounting firms, they'll have good record keeping because they're regulated and they have a professional duty to keep them. In those circumstances, the defendant should confirm now that they give authorization for those parties to be approached. And what we don't want to find is the defendant say, oh, well, we're not going to give you permission. You need to make an application against those third parties, and then we will have to incur the cost and the jurisdictional difficulties in trying to apply against those entities where they exist and where their records exist. So the defendants ought to give that consent. There's no reasonable basis for them refusing it.
Yeah. Rodman, you wanted to say something?
I did, and I'm sorry for cutting across, my friend. It's rude. What I wanted to say is that it would be of assistance to actually narrow down the time that we're talking about, the material period. It's not something that we've really had much of a discussion about. The reason I say that is this: what we don't want to do is to find ourselves being compelled to give to find and locate and produce all financial statements, documents, etc., checks that other external agencies have done on goods, which go beyond the relevant period, because that I say would not be necessary or indeed proportionate. So my intervention was in order to assist that.
Well, sorry, Your Honour, I'm so sorry.
It is a question of sensible confining of interest to what is relevant.
Exactly.
But I'm not going to enter into the detail of that at the moment, because I would hope that you'd be able to sort it out.
No, and we don't. I don't think. I think I can speak for my learned friend. We're not asking you to delve into that sort of detail, but I wanted to flag that there needs to be some sensible parameters. All
right. Back to you, Mr. Shibdi, then.
I'm grateful. Thank you, Your Honour. So moving on to the third topic, I promise we are making progress, swift progress. So thank you. The next topic is the contemporaneous emails. Now, the claimants, as we know, the defendants conducted this internal investigation in 2017. It involved their IT department. We are told that when they first discovered the fraud, this is it. I don't need to turn it up, but I'll give you on the reference. That in their the sixth defendant's document production statement of paragraph 18, it's explained that when they discovered the fraud, in inverted commas, they then investigated the email addresses that were being used by the CEO and the CFO, and they noted that they had been using private email addresses in addition to their business email addresses. But anyways, so there's evidence that 2017 investigation included investigating emails, which is exactly what you'd expect the IT department to hunt for. And then similarly, in their application to set aside default judgment, the defendants say, moreover, as soon as they learned about the existence of this claim, the applicants immediately carried out an extensive internal investigation to locate emails and documents relating to the claim generally in the purported guarantees. So again, extensive internal investigation to locate emails. That was in their application to set aside default judgment in 2020. And there are a number of other references in the evidence to running forensic searches for emails and for documents, instructing the internal audit team to look for email accounts of the finance team led by Mr. Mohanan. That was all in 2020. At that stage, there was no suggestion that the defence were missing any documents or missing any material in documents. If anything, as I said, they were trying to persuade the court that there was a massive body of material to support their defence, which is why default judgment ought to be set aside. The first suggestion that the defendants may have lost data was after our request to produce, which was in mid-August. At the end of August, they said for the first time that there'd been no backups of Mr. Hayder and Mr. Mohanan's emails. And then that, after some more correspondence about the shortcomings in their DPS generally, they have produced some very recent, as in the last month or so, correspondence with their email providers, which say that data has now been deleted. And then if your honour turns up my learned friend's skeleton, please. It's paragraph 39.
I have it.
And it's it's really the second sentence, third sentence. With respect to their email service providers, the defendants did not think about the possibility that they might lose permanent access after 2017. After trying to retrieve that data, they only know now that their service providers permanently deleted it soon after those accounts were closed. So what the defendants are saying is that the emails of the key protagonists have been lost because the service providers have deleted the accounts. And there's not any proper evidence to say when that happened, but in the DPS, it's suggested that that happened in late 2017 or early 2018. Now, the chronology is really important because obviously they knew about our claim by mid-2017, and their internal investigation had happened certainly by late 2017. It probably happened at the beginning of 2017 or even maybe in 2016. So they knew about the alleged fraud on their case, and they knew about our claim before all this key data was lost. And that is very troubling. I mean, if that loss of data in fact occurred during the course of these proceedings, and this point may still occur even if it occurred during the course of the criminal proceedings, but that would be a serious default on their part. And the court would often, well, the court might actually impose some sort of sanction on them for doing that, but certainly we'll be in the territory of adverse inferences. But as your honour will know, whether to make an adverse inference, the court does need quite a lot of information about what's happened. And generally, what the court is trying to assess is whether the loss of data is an inadvertent error or a deliberate step taken by the party to avoid relevant documents coming into the domain. But the story that they're telling is a very curious one. We had this internal investigation involving the IT people, probably in early 2017. They knew about the claim, our claim, around that time, by mid-2017. The server data was all still in existence at that point, but no one seems to have captured the emails of the key protagonists. So it's a very odd story. It's all the more odd when you look at what we then have got. So in one of their productions, they produced some emails involving different people. There were a small number of emails where the metadata, so that's the computer code embedded in the email, suggested that the emails had been received by Mr. Mohanan. Now that doesn't mean that he's, as we understand the position, doesn't mean he's the sender. It means that the copy that they've produced was a copy that was received by Mr. Mohanan. And Mr. Dylan Malone explains this in his evidence.
I remember that. But,
do you remember that? So,
where you're hitting on this one?
So
What would you, in the end, be asking me to do about this now?
I am asking Your Honour to make an order that they give a proper explanation supported by documents in relation to both obviously the university documents, but also the destruction of documents. So they need to give us chapter and verse on the destruction.
Well, that
because
should be by a document production statement, is it not?
well, it is, but there's such a great difference between my learned friend and myself as to what that statement ought to contain, because his position is that they've complied even though they haven't explained any of this properly. So I'm just trying to, perhaps I'm labouring the point, but just trying to make sure that we get chapter and verse on the destruction of documents. And in particular, we'll need to know the timing, circumstances, what efforts were made by whom. And we'll also need to know what's left. So, for example, we are told that Mr. Hayder's computer is still left, but it's been deleted. I mean, these days, there are document recovery people who can achieve amazing things, including recovering hard drives easily and at limited expense. So we do need a lot more information, and the court is entitled to that information in our submission, so that the court can then decide on the question of whether to draw an adverse inference.
Are you entitled to have production of his computer so you can export?
We would, yes, we would ask for that. We would ask for they can do an image of his hard drive, and it's without drawn to the technicalities, but there's a way of reproducing the hard drive, the deleted hard drive, and then it can go off to the recovery agents, and also they should be ordered to use all reasonable endeavours to help us with that. So if we need access to passwords, etc., they should be giving us that.
Well, we need to come trying to get a handle on what I'm being asked to do. And that's not the sort of thing that I dash off in a moment in this.
Well, on that, Your Honour, the only order I'm asking for in this hearing is an order really in relation to the universe of material. As Your Honour has identified, once that happens, there will be further inquiries, conversations that need to happen between the parties. And if they can't be agreed, we might need to come back. But I'm hopeful that in light of Your Honour's helpful observations during this hearing, the defendants might understand that a different approach to the one they've adopted to date is required, and they may be more cooperative, in which case that would dispense the need to come back.
Well, at the end of the submissions you'll make, do need to know, and Mr. Osborne needs to know, with some precision, what order you're asking me to make now, which I've made plain. I hope that it's not going to be going to the nitty-gritty, but I hope it will be one which will get that matter moved forward. You're going to have to tell me what.
I'm grateful, Your Honour. I understand that, and the point is foreshadowed in my skeleton argument. There is a section of my skeleton which deals with the order that we're after. And if I may, Your Honour, I just want to finish going through a few of these points, and then we'll come to that in pretty short order. Your Honour, and just to follow through on this point about the destruction of documents, it's not just Mr. Mohan and Mr. Hayder's emails, so the CEO and CFO's emails that apparently have been destroyed. There have also been the destruction of the email account that belonged to D6 Ahmed. So that is another thing that will need to be covered. Now, can I just
belong to who? I didn't catch.
Oh, so I'm sorry. The universe of material that has been destroyed allegedly includes Ahmed's emails as well.
Ahmed, okay, thank you. Yeah.
The 6th defendants. Now, I won't labour the point, but I just wanted to address Your Honour on the explanation that has been given by the defendants to date as to why they have those emails with the metadata that we mentioned. Now, they haven't put, I appreciate this is a very technical question, and there isn't expert evidence from either side. There is evidence from Mr. Dylan Malone explaining what the metadata shows, and he's just reproduced the metadata. Your Honour doesn't need to get into that technical question, and I'm not asking Your Honour to make any ruling for it. But what I am asking Your Honour to note is the moving explanations that we've had from the defendants as to how those Mohanan emails are in the defendant's possession, and the case changes. And I wanted to show Your Honour that, because again, this emphasises my point of pinning them down in evidence on what the truth is. So if I take Your Honour to my learned friend's skeleton.
Yep.
And it's paragraph 83, please.
Yep.
So I mean, without the greatest respect to my learned friend, this submission rather trivialises what we had found. It's not one email. There are a number of emails that have this same issue. And in addition to that, as Mr. Dylan Malone explains, there is also a whole body of Mr. Mahonan's emails that are attached to a report in the criminal proceedings. And the question is, where did all these documents come from if the defendants are telling the truth that Mr. Mahonan's emails were deleted? Now, the explanation put forward here is that the identified email was attached as a native file to an email that's still available. So what they've said is the reason we've got an email with that metadata is because it was attached to another email. So we wrote to them, having seen the skeleton, and said, well, can you give us that email that you say attaches one of these emails? And we also explained this is not isolated to one email. There's a whole body of material. And we said, give us that email, or if you can't give us that email, then you ought to withdraw this paragraph. Now, what came back was a different explanation. So they've abandoned this case. They're no longer advancing a case that any of these emails were attachments. They've now come up with a new explanation sent late last night, that these were some sort of, I'm not quite sure I understand it, some sort of backup. That's how some of the native files were created. And for the other files, their explanation is that these were attached to a criminal complaint made by the CEO against the CFO, which were given to them by the Abu Dhabi prosecutor. So if somehow, it's very difficult to understand, the CEO managed to get a copy of the CFO's emails, even though their evidence is that only the CFO had access to them. But anyway, somehow he managed to get hold of them, made a criminal complaint in which he attached them, and then the Abu Dhabi police gave the defendants back the disclosure of their own CFO's emails. Now, that was in a letter this morning, before this hearing. I mean, it's a movable feast. But this paragraph is wrong and is no longer my learned friend's case. There is now a new case. And this instance is really a reflection of what we've had in so many different areas. Just a change in case, no evidence that makes any of these points. And that just means that the defendants can move from one position to another. And it really emphasises in my submission the importance of having affidavit evidence from them that is thorough and that they can be held to, because it's no way to manage the Part 28 process if the story changes every time we point out why it must be wrong. And just so as a final addendum on that, and so when you look at all these sorts of problems, the fact that there are no documents involving any communications between the defendants and no communications between the individual defendants and the companies at all during the relevant period is something that should be treated with great scepticism. I showed you at the beginning how D6 and D8 had day-to-day involvement in the businesses. These are sophisticated business people running an enormous and sophisticated business, going into the office on a regular basis. We live in an electronic age. Their business ran at least in part electronically. It is astonishing that there are no documents. Now, if ultimately that's their evidence, that may be something I need to cross-examine on at trial. But again, as a matter of honesty, they ought to be frank with us as exactly what they had at the time, what they were using, platforms, etc., so that we can then make an assessment of whether there's a way of recovering data if it genuinely has been deleted. Now, unless on has any questions on that, that was the end of that topic, and I've only I'm actually going to move to a separate topic which is shorter, and then I've got a few very short points, so we are nearly there. But I'm grateful, and perhaps at this stage I can hand over to your honour to decide whether you want to hear from my learned friend.
I don't have any decision. I want to hear from him. I knew it on this topic. No, I think let's move on to your next topic. My apologies, I misunderstood. Move on to your. I think I misunderstood as well. Yes. But Mr. Osborne will be heard.
The next point is a short point, and it's just to do with the document capture exercise and the search exercise. Now, we have previously raised the concern that the defendant's DPS appear to suggest that they personally or their staff have conducted the reviews for relevance of documents. We've raised this point in correspondence, and we've also raised this point in our witness evidence. The defendant's response is in their skeleton. Now, in fact, there's some measure of agreement between us. If Your Honour turns up my learned friend skeleton at paragraph 31, Now, the way that my learned friend approaches this is he said, and it's just normally the way things are done. He says it's essentially a two-stage process. The first stage is a document capture exercise, and the second stage is a review for relevance stage. And what he says at 31, first sentence, is plain there must be a first-level retrieval exercise, but without the client applying their judgment about what ought to be given over. So as we understand his position, he's saying the client can be involved in document capture, but he accepts that the client ought not to be involved in the relevance review. That is, as I understand it, is his position. If I'm incorrect about that, he can tell me now.
Carry on.
No, that's correct.
In later.
Great. I'm grateful. So we're agreed that the client ought not to be doing the relevance review. We're not entirely aligned on document capture, and although we're probably not that far apart. If Your Honour turns up my skeleton argument, we've cited a passage in my skeleton argument at paragraph 37 from the 5th edition of Disclosure, and I'd be grateful if Your Honour could just read the words in italics.
Yeah. Yes. This is what I had in mind when I talked about the solicitor's professional responsibility earlier on.
Yes, and it is also what we have in mind. So we're not asking the solicitor to do anything more than what is the usual practice and what's envisaged by this paragraph. What I had in mind was requiring the defendant to file a witness statement from their legal representatives confirming that had been done. And giving some particulars of what had been done, but I'll come back to that. Your Honour may still require some persuasion on that.
When you come back, you'll need to persuade me.
Okay. Well, I'm very grateful for Your Honour's indication. So anyway, there's two stages. The first stage is document capture. The second stage is review for relevance. We say that the solicitor should be involved in the document capture exercise as well, and that's, we say, what the paragraph envisages. Now, in this case, it is the defendants and their staff who have been involved in both parts of these exercises. No, I'm not saying all aspects of the exercises, but they have been involved in both aspects. Now, I don't need to legislate for other cases, but on the facts of this case, that is wholly inappropriate, and in particular the use of the defendant staff. And the reason I say that is that we know that the defendants have previously accused 5 of their previously loyal staff members of fraud, have reported them to the police, have tried to persuade the prosecutors to indict them, and for one of those defendants, they spent a year in prison as a result of a travel ban obtained on the defendant's pushing. If you have an employer who acts in that way to former employees, and you're an employee tasked with finding documents, and you come across an adverse document, you might think twice about whether you hand it over, especially in circumstances where none of these individuals involved in the process are DIFC qualified, none of them understand the rules or the professional obligations, none of them have a responsibility in the way that an officer of the court does to ensure the process is done properly. And we can see from the 6 defendants' DPS that their staff have been involved in both aspects. I just want to show Your Honour that. We can find his DPS in bundle B, tab 11, starts at page 162. Does Your Honour have that document?
Almost.
Okay, I'm grateful.
Yes, I have it now.
Thank you. So we'll start at paragraph 2. He says, I know the background to the claim, the ongoing proceedings involved in the Delma Group, and the search is undertaken under my instructions by Delma Group's IT department on behalf of the corporate defendants. So he explains there that searches have been carried out by the IT department. That's the first point. Then there are a number of different items dealt with in this statement. The next is that if we go, there's some material in here. Although we said it's very unsatisfactory on the electronic documents. But what seems to have happened is keyword searches were applied to the electronic documents. They say 171 emails were identified, and then they were handed over to the legal representatives. I want to then focus on what happened for the hard copy. Actually, no, we'll deal with the personal records first of all. So if you go to paragraph 20, he says, I confirm that I have carried out a reasonable and proportionate search to locate all unobjectionable documents to the claimant's RTP. He doesn't actually explain what unobjectionable documents are. But he then goes on to explain the searches, for example, on his mobile phone at paragraph 25. I have searched the mobile phone devices currently in my possession using with my mobile phone numbers in the UAE and Morocco for relevant data regarding this claim for the period 2015 to 2017. None of those handsets held any relevant data. So he is looking for things that he thinks is relevant. And he has made a assessment. And you'll find the same statement in each of the individual defendants' DPSs. So they have each made their own relevance assessments, at least in relation to data on the mobile phones. And then if one goes back to paragraph 19, you can see what hard copy searches have been carried out in relation to the corporate defendants. And he says at 19, in addition to the searches carried out on the email accounts listed above, I have instructed various employees within Delma Group to carry out manual searches for hard copy documents in Delma Group's archives. Now, that is all that is said on the hard copy search. We have no idea what they searched, where they searched, how far back they went, what instructions they were giving, what they found, and what was handed over to the legal representatives. Now my learned friend in his skeleton, we'll come to this in a minute, gives gives all this information as he says as to what happened, but none of that's backed up by evidence. This is the only evidence we have on what they did. And just on those hard copy documents, and turning our minds back to those 2016 accounts, that hard copy review didn't find the audited accounts for 2016 of the first defendant. So we can infer from that it was a very unsatisfactory search. And as I said, it may well be that those employees, loyal employees, thought that it might be above their pay grade to be handing over lots of documents. So the court can't have any satisfaction that this has been done in a responsible or professional way. Now, I'll say a few words about what my learned friend says in his skeleton. If we go back to his skeleton, if we look at 32, he says the defendant's legal representatives carried out a reasonable and responsible approach to the first level retrieval exercise by directing defendants to apply a series of keywords to all available electronic data. And the product of those keyword searches was then transferred to the defendant's lawyers and assessed for relevance. Now that is wrong on the defendant's own DPS, because I've shown you that when it comes to their mobile phones, which is obviously electronic data, there was no keyword searching. Instead, each of the individual defendants searched their phones for relevant material and decided there was nothing relevant on there. So my learned friend, regrettably, is just wrong at 32, and there's no evidence to back up that that's what happened for all the electronic data, not just the email data, but all the data. And then 34, he says, this is the hard copy material. He said hard copy material held at the defendant's premises has been identified as emanating from the first defendant's previous employees involved in the fraud scheme. That material was sent to the defendant's representatives, was assessed for relevance and produced accordingly. Now, I don't understand the basis on which he says that, but there is no evidence to support that exercise happened. All that we can see from the DPS is that it was the defendant's employees who searched the hard copy documents. And as we know, they missed the 2016 accounts. And we haven't had any explanation, and you'd expect there to be a witness statement explaining how the 2016 accounts were missed. And we haven't had that. One would have expected an apology to the court on how the court was told that document didn't exist, and suddenly it does, and we haven't had that. So in my submission, regrettably, paragraphs 32 and 34 aren't quite accurate. And as a result, we asked the court to use a great deal of caution when looking at what the defendant is saying, unless it is genuinely backed up by evidence. So, Your Honour, those are my points on the searches. I then just need to really put it together and address you on the order, but I'll pause for a moment there.
No, well, I think we're at the point where we need to know the orders you're asking me to make. It strikes me that it's going to be necessary to have something more than what you tell me orally here. I think the way to really try and get some definity is for you to have a more detailed or a written statement, sensible rather than, if I may put it, an answered statement of what you want. By all means, tell me about it now, speak to it, but it strikes me that we're going to need that, and then Mr. Osborne may need to respond to that piece of paper.
Yes, well, I'm grateful, Your Honour. So, I'm sorry to interrupt,
but what I would like from you, to be honest, is I want an order saying so and so, including, for example, that an affidavit from an officer of the first defendant stating that 1, 2, what searches I made, whatever it is that you ultimately say as a result of your submissions, so that I know Mr. Osborne can speak to it and I can tick it or cross it as the case may be.
Yeah, well, I'm grateful for that, Your Honour, and we agree with that. So what we had in mind was let's start with the officers of each of the corporate defendants and the individual defendants. We would want an affidavit from each defendant for the corporate defendants given by their a proper officer, and setting out the authority for them to give that affidavit. And that affidavit should address, firstly, the universe of documents, and let me just explain that in a bit more detail. That would mean that on the electronic documents from 2014 onwards, that all the electronic computers that were used by individuals in the finance department and within the senior management of the defendants, a list of all the email domain names and email accounts used by those individuals, identifying in each case the provider of the server, a list of all the backup systems, backup devices, and other storage devices that the defendants had in play at that time. So that's the electronic documents. Then next we would want information about their hard copy filing process. So what hard copy records were stored, at which locations, by whom. Then 3, we would want a list of their external professional advisors from that date onwards. And we would want authorization that insofar as they didn't have access to the documents of those communications with those external professional advisors, that they should give consent for us to approach those providers ourselves. And then 4thly, in relation to each of those categories, an explanation of what documents no longer exist, and if there have been destruction of data, chapter and verse as to how that data came to be destroyed, and what was destroyed. And then there's a 5th point, Your Honour, which is not something I've spent time on yet, but it's a very short point. The defendant's case is that some of the facility documents bearing their names were forged. Now, we have understandably asked them to identify the documents in asked for the documents in the parties' document production, which they say are forgeries, and they've said, "Oh, that's a matter for evidence. We'll tell you later." Well, on the current timetable, expert evidence is due in 6 weeks' time, and we need to know what their case is on forgery. So we will want
to stop there to understand something.
Of course.
Presumably in the set-aside application, sorry, I'll start out. The bank presumably holds originally signed documents. Is that step 1?
Yeah, we do. I don't have at my fingertips exactly what we have, but yes, there were originals, and they have previously been provided for inspection. But I can't at the moment tell you on exactly what those were.
Okay, but the second thing is they would have been provided for inspection, and apparently a handwriting person or an expert has said those signatures are not necessarily genuine. So what more is necessary?
Well, there are lots of documents that bear the defendant's signature, and I mean there are lots. I mean, even for this transaction, there were account opening forms, there were all kinds of KYC checks, and they need to be clear with us as to which ones they say are forgeries, because we're not talking about a small number of documents, and there are obviously documents in the bundles for other similar looking facilities as well. And we need to know whether if for example, the defendant's case is they knew nothing about this transaction, then it is probative if they entered a very similar looking transaction on very similar terms at the same time. So they need to tell us which of those documents are forgeries. And they must have turned their mind to these questions. Sorry, I'm interrupting you.
Well, this strikes me not as a question of production of documents. This is a request for information exercise.
Yes, it is, and I'm so sorry I didn't explain this properly. We have previously made a Part 19 request for this. We made a Part 9 in the proper way, in the usual format, and I'll show you. Perhaps I can show you that to Your Honour.
Well, but hang on a minute.
Okay.
Is this before me now?
This was on the agenda for the hearing that we put before the court. We sent that agenda to the other side. They raised the point that it wasn't a question of document production, but they said they hoped to resolve it before the hearing. We've heard, this is a request made back in September. We've heard nothing on it. If Your Honour doesn't want to deal with it today, we can come back. But it is a point that I will need an order on.
I deal with it if it's agreed that it is before me. But if there is some question of whether it's before me, maybe not.
Right. Well, I'll allow my learned friend can address you on that in a moment. And sorry, Your Honour, there was one further category that I just wanted to make it clear that when we're talking about the electronic document, we're talking about the Delma Group and all its entities. Now, I see on this call, I've just noticed on this call that one of the participants is Alanud, who is one of the sisters of D7 and D8, and she's also a daughter of D6, Ahmed, and she was involved in a company called Attico. Attico was the recipient of that 1.8 million that was advanced by us, and she appears to be the only individual out of the individual defendants who they accept still has emails from the relevant period. And by a lucky chance, we identified in some correspondence they sent us that she had access to her emails from 2016. Wasn't something they volunteered. They'd not included her as a custodian. They're very keen to try and keep her out of this. It's obvious from her participation today that she is involved in this. And for the avoidance of doubt, their evidence on the electronic documents ought to include her and Attico, her company.
Include in what way?
Well, they need to identify the email accounts that she was operating, the devices she was using, etc.
Why?
Because so let me just go back to the
Well, we're looking at documents in the custody or control of the various defendants. Her email, prima facie, her email account does not seem, or whatever's in her email account doesn't seem to be of that kind.
Well, sorry. Sorry, if you just one moment, Your Honour. So she is the owner of and the principal behind the fifth defendant, Delma Emirates General Transport. She took ownership of it in November 16, which is in the heart of this chronology, and her documents ought to be in the possession or control of that company. And if they're outside the possession or control of that company will have to give evidence on how she is authorised to conduct business on its behalf, but they don't have access to her documents.
Well, that's a question of that company. If it is a company, and I think I'm not really sure what it is, responding to an order that's made against it. It's not a case of an order against her.
Yeah, we're agreed, Your Honour, and I'm not asking for that. That's right. I'm only asking for questions against the defendants, but we want to make sure that the net of the defendants is cast appropriately.
Okay. Now, can we just discuss where we're at in my making any orders that I might make at your request of the kind we've outlined? Under the case management order, if I remember rightly, requests for production of documents were to be made and responses by a certain time. Now, the response is Rule 20. Although, in fact, there have been produced document production statements, in document production statements, as I understand the rule, are the result of a document production order. At the moment, what you are really asking me for is a document production order, but with additives, if I can put it that way, of the kind that you've indicated. So that the document production statements were produced so far, I'm not saying it wasn't a bad idea, but in fact they were not in accordance with the scheme. Now, do I have it right? Do you agree with that?
You do. All they were obliged to do, it was still something quite significant, was to provide the information under 2820.
Exactly.
And they didn't, and that, it's up to them how they do it. They chose to put it in a document production statement, but as we have submitted earlier, they haven't complied with that. And that and in fact, sorry, just to emphasize this point, the scheme involves parties being frank at the beginning, before requests are made, as to what they have, what the universe is, because this process really, in our submission, run off the rails because they've not been open about what they have. And so what we will now need is really to rerun the process. We need proper explanation of what the universe of material is. Then we can agree some proportionate searches. Hopefully they can be agreed without further court intervention, and then they need to produce. So as Your Honour said, we can really get back to the timetable. And it may be that the only order I need is the order today about the universe. And it may well be that we can agree the searches. If we can't, I will need to come back and ask for a document production order on those, but I hope not.
Yeah, well, that's what I was going to say. Really, what you are asking for me, I think, is the document production statement in stages.
Yeah.
I don't frankly see why that can't be done. You are dissatisfied with the Rule 20 response. You are entitled then to come forward and ask for orders. You may ask for them in stages. Ultimately, if necessary, a formal document production statement. I think that's what we're about. We'll hear what Mr. Osmond says about that also. But if that's right, then I'm back to my point. I certainly would like to know, and I think Mr. Osmond is entitled to know, with precision what you are asking for here and now in writing. And I'm wondering whether, unfortunately, we need to adjourn to ask you to provide that to him and me, and come back to the battle.
Well, may I make some points now that I think, again, forgive me if you've got across, it's just one of those hearings. Can I make some points I think would assist with that?
Before you do, I'll just check whether Mr. Shivji has any more things to say in response to what I've just suggested.
Well, I agree with Your Honour that it would, in light of the way this hearing has gone and where Your Honour appears to be going, that the way forward is an order in those terms, and that we should produce a draft. Can I suggest this? I've identified the principles that the order needs to cover, and if Your Honour, having heard my learned friend, if Your Honour agrees with the principles, then the parties can be sent away to agree a form of order. And if we can't agree a form of order, we can come back before you. But it may well be, and this is often the case in my experience, that the court having identified the main bones of where it wants to go, the parties are then left to deal with the minutiae, and the matter is only put before the judge if there's a serious disagreement. I'm just conscious that we ought not to be absorbing more of Your Honour's time than we need to. And if Your Honour is with me on the principle, then we ought to be able to agree the mechanics.
All right. Well, I'll ask Mr. Osmond to address me, but at the moment, I am uncertain whether the best way to go is to get a formal piece of paper and deal with it with formality later on, or whether we can get to some suitable result immediately. So I'm by no means firm on which way to go. Mr. Osmond.
Your Honour, I think what would really assist is an understanding of what it is that my learned friend is asking for effectively the statement to cover, and then setting out the parameters of what needs to be done that, and we can work towards getting that information together. So, for example, the suggestions that I was making earlier on, that the digital storage devices are tabulated, what are they? What is the universe? Please may we have an explanation for that. I can see the sense in that, and something I said earlier on. The list of, for example, the custodians, who are they? What's available? Please tell us about that. We can certainly do that. I think the key words can probably be left until later on, because as my learning friend says, and I think this is right, until one understands what the universe of information is, then that's at that time the keywords need to be determined, although keywords have been given already. So I think the starting point is this, for my learning friend to say, please identify what it is that you have digitally and in hard copy as well. In terms of digitally, what information, what storage devices are still available at the companies for each defendant. That seems to be sensible. In terms of hard copies, to identify, give a better understanding of what hard copies are in existence at various locations. So what is it that's still there? And that seems to me to be the best starting point. And then to work together to determine, now we understand that universe, what is to be done with that universe of information, what search criteria do we apply, and to give and to agree what search criteria ought to apply, and then apply them. So that sort of stage response, does that give some assistance as to really where we should be going now?
Not enough, because he really has foreshadowed he wants more than that, by way of, as it were, swearing to the accuracy of matters and what has been done and how it's been done. That kind of also, in other words, it's not just a case of providing a list of accounts. Do you have a general position on whether that is something that you could agree to?
My apologies, he did say that, and that is something on the table. I hadn't realised it. I think if we just understood what it is that, what I don't want to be caught by is if we agree what it is that needs to be sworn to, if we understand what it is that he's asking for confirmation of, we can work to give that confirmation. And I don't want to be in a position where we're going backwards and forwards saying, well, you haven't actually explained that and you haven't explained that. That's what I'm trying to avoid, is that whatever document is created now, whatever series of requests and requirements are made of us, it is definitive, so we can go away and work on that. That's really what I'm trying to achieve. And I think my learning friend is saying that's something that can be given, unless I've misunderstood it.
Well, I agree with that, in the sense that I think that there should be a clear statement of Mr. Shivji's requests.
Yeah.
I should either tick or cross each one of them, and what is left for you, between you on the detail, is something that we can confidently expect you'll agree on.
Yes. Can I raise one other point? Forgive me. Can I raise one other point in relation to that? It's just when he's setting out that sort of that list, there has to be an agreed time period, because what we don't want is to be realistic on what sort of material that we need to look for. So I think there is an approach to defining what the relevant period is. If he can work with us too, so we can settle on what that relevant period it would very much assist us, because it's going to really narrow down the type of searches that we need to do. So if it's proportional.
Mr. Steve, you may be able to state relevant periods as appropriate in this piece of paper.
Quite.
Can I suggest this is the way forward? I don't think we can achieve what we're talking about tonight. Regrettably, I think we're going to have a break tonight, in the sense of tonight here, I might say.
Not yet.
Mr. Osman, I do think that there are reasonable grounds for discontent with what has happened on your side, if I can put it as generally and politely as that.
Yes.
And I think there is reason to move forward along the lines that Mr. Shivji has indicated. What I think that he should do is produce a piece of paper saying, I want from me now orders in the terms of, fairly precise. I would hope that you then have a bit of a discussion, and you are both approaching it with good sense, and you may not be able to reach entire agreement, but at least you can agree on any differences. And then we come together again in a couple of days' time, and on those matters of disagreement, I tick or cross, and that's it. How's that?
Respectfully, I think that's an approach that we would absolutely welcome. Again, without labouring the point, what I don't want to do is to fall into the trap of criticism by saying, well, you haven't properly understood what we're asking for, and so you haven't given it. So we're going round in circles again. So that sort of codified list, as it were, would be of material assistance to me. Can I say this? My learned friend has made some points in relation to earlier in submissions in respect of other issues. For example, the UMesh emails. For example, the idea that material has been destroyed by Ahmed. I had responses to those. I detect that Yuan is not terribly interested in litigating those sorts of back and forth, other than for me to say I don't necessarily accept all of Mr. Shivji's criticisms. But in terms of whether that assists us on getting forward and putting something together so we can actually get to the next stage, I'm conscious of the fact that we can just get to that point. So the only thing I wanted to say is that there are matters I would have addressed on if we were dealing with a full debate in relation to the litigation. Is it necessary?
That matter of destruction or perhaps insufficient attention to retention is something which may or may not come up at the trial. If it comes up in this list that Mr. Shivji puts forward, I'll rule on it. If he wants something about that, I will rule on it if there's dispute. It may help say I'm more interested in looking forward than laying the groundwork for cross-examination at trial. It doesn't. This exercise is not part of that.
No, it's not. It's not.
They're not documents. But I'll wait and see. That's up to Mr. Shivji whether he wants to ask for something that raises that, and if he does, I will rule on.
Yes, I simply wanted to make the point. I mean, there are a series of allegations that I know Mr. Shivji is seeking to formulate. So, if in due course you can cross-examine for inferences to be drawn, and I don't want to engage in them now. But it's a matter of evidence in terms of how things were dealt with. For example, what's happened with Ahmed's material. For example, what he meant by I've looked to relevance. Then that doesn't strike me as part of this process. But if there's something that needs to be explained, that will come out when Mr. Shivji explains the process, and we can rely on it, and then we can deal with it in that way.
It's looking forward,
exactly.
Up in some way with disclosure and DPSs in due course. If it turns out later on that the DPS is wrong and sufficiently wrong that the application is out the defence, that would be a very interesting exercise. Or it may just be a matter of, with any luck, I will not be involved. Okay. Well, sorry, who was that?
I was just saying, I think it seems to me then that what we need to do is to get that document, and so we can work forward from that process. That seems to be the agreed place to start.
Right. Now, I don't know the availability of you gentlemen. I would think that this will need say a day to produce the document, or the rest of today or time to produce the document, and then a day at least to discuss it if you both have a bit of time to do that. So maybe, do you know your diary can we actually make a time, same time, say on Tuesday, to try and put them to bed one way or the other?
I know my diary, and I'm afraid I'm not available until Thursday next week at the earliest for a hearing.
Your Honour, if Thursday works for you, I could do Thursday.
Okay, well, should we make it the same time Thursday? Charlotte, I think you're listening to this.
Yes, so is it this Thursday or next Thursday?
It's Thursday coming up.
Okay, so Thursday the
28th.
The 28th.
I'm so sorry. I'm so sorry. I've just checked my diary. I'm overseas on the 28th. I'm coming back on the 28th. It's my fault. So I wouldn't be here on the 28th. So if it's possible that either, I know Friday's not possible, but the 30th or the 31st, I'd be grateful.
This is getting a little difficult.
Yeah.
What about, did we discount Tuesday for some reason?
Can I just say what my commitment is? On Tuesday, Wednesday, and Thursday, I'm not in the country, so I'm flying out on Tuesday. Wednesday, I'm not going to be here. Thursday, I'm returning late Thursday evening. That's my commitment for next week.
Well, I am right same time next Friday.
The DIFC courts is not operating on Fridays.
Friday, of course, yes, I'm sorry. Yeah. Indeed. Mr. Shivji, what's your preference as to dealing with this? I don't. I'm sure you don't want too much time to go by, but what's the best way we can deal with it?
Is this a matter that Your Honour would be willing to deal with on paper? I mean, my suggestion would be that if there are any oral submissions to be made, the parties do that now, because I understand that the drafting will require careful attention. But in my submission, I've outlined the principles that I want this to cover. And if my learned friend has any objections to the principles and wants Your Honour to rule on them, he should ask you now. The one point that I did detect that he seemed to have an issue with is giving evidence about the destruction of documents. Now, I understand Your Honour's point that this process is about document production, not laying the ground for trial. But in our submission, it is normal practice for where there has been the destruction of documents for the court to require evidence on it. And the reason for that is that it then affects the searches that are applied. Only when one has information about exactly what's left with the universe, then one can identify sensible searches to be made to effectively try and deal with the fact that a significant body of documents, relevant documents, has been lost. So it's in that context that I would raise it. And in our skeleton argument, we did produce an authority. It's the Glaxo case. I don't need to turn it up now, but if this remains an issue, it may be something Your Honour wants to look at. But in the Glaxo case, a party was obliged to give disclosure. There was an electronic platform which had been destroyed during the currency of the proceedings. It appeared to hold relevant documents, and the court said, I do need to understand what's happened. This is a matter of a party's frankness to the court, and a party should give sufficient information so that the court can understand whether this was an inadvertent deletion or whether something more sinister. And that's for a number of reasons, including that the court wants to police its own procedure. And if the defendants have deleted documents during the currency of this procedure, that would be during the currency of these proceedings, that would be a serious default, which the court may well want to impose sanctions on.
Yes.
I can take a grip. I can take a grip of this, because I think my hinting at that, my objection to what my learned friend says, is set a rather a hair running. My objection to what my learned friend says is that Ahmed destroyed his material on his mobile phone. That's not the case, and we can explain that. What actually happened is that he checked his mobile phone for that time period to see if there's any content, and couldn't find anything, so nothing was produced. So that's where I was going with that. But I think my learned friend's suggestion as to whether we can dig in and get this done, a lot of this done now, I would like to take that up. List of domain names, if that is something that my learned friend is asking for in his document, yes, we can give a list of domain names. That can be done. I've just made a note of what it is he is asking for. A statement to say what's happened to material that is no longer there, we can give that as well. We've given some information. If it needs to be put into a formal statement or an affidavit, then we can set to and get that done. So I can take that one as well. A list of professional advisors, I can see no reason why a list of professional advisors cannot be given. So if my learned friend wants to include that in any potential document, then we can certainly do that. My learned friends ask for a authorization that about consent with those professional advisors. I haven't got instructions about that, but that is something that can be included in the document, in the request that he makes in that document. And then we can go away and deal with that. And list of, I think, keywords that have been applied already. We haven't given that information, but again, we could put that in response to a document that's being suggested. So it may well be that the contents list of what my learned friend is asking for, that yes, that's something I can engage with now. And if that contents list is determined now, then we can go away, have it drawn up, put it back before Your Honour, and then go forward again and seek to comply with it. So if that's I'm happy to do that exercise now.
All right. Well, I think then what this seems to me to mean is we will adjourn this hearing now. Mr. Shivji provide the draft orders he wants me to make by the end of. Can you do it by the end of today?
Could we have 24 hours?
Right, within 24 hours. And Mr. Osman, will you have the opportunity to look at it before you go away or not?
I'll certainly try to do that. I've got Monday.
Yeah. All right. Well, there will be discussions between counsel, hopefully to a result of some kind on Monday. And I will deliberately leave up in the air what happens after that. Depending on the discussion, a joint letter to the registry, please, saying we are almost agreed, give us some more time, or we are agreed except we are disagreed on 3 points, let us fix a further hearing to resolve them, or whatever the position is. So yes. And we will then find a time as soon as possible. I think that's the most practical way of dealing with it.
Agreed.
Okay. Mr. Osman agrees. Mr. Shivji is looking a little puzzled.
I'm sometimes puzzled. No, I'm content with that. Your Honour, it's subject to one slight revision. Things have a bit of a tendency in this case to drift. I mean, there has been, as regards, for example, the complaints in inverted commas about our document production, we invited the defendants to propose keyword searches back in August. We had no engagement from them until after this call, until within the last 7 days. And so I mean no criticism, but sometimes regrettably things don't happen as efficiently as they ought to. So deadlines are very useful. I mean, my suggestion would be that we'll produce our order within 24 hours. My learned friend and I can speak tomorrow, and we really ought to try and agree whatever we can. And if we haven't reached an agreement, then we should just put in the order with a joint letter from the parties to the court, setting out the areas of disagreement on Tuesday, and then Your Honour will have that. I'm grateful for Your Honour's invitation that we come back for another hearing. My submission would be that should be very much the last resort. It's troubling for Your Honour. It takes time to find a hearing date that suits all the parties, and the timetable for this case is bearing down on us. I mean, witness statements are due in 3 weeks' time. I mean, it seems to me that might need to be pushed back by a couple of weeks. But I'm very keen to avoid long delays, and certainly don't want to do anything that might jeopardise the trial date, which we still think is perfectly viable.
Well, I agree with the undesirability of any delay, but I think we'll leave it the way I said. But your letter may or may not be able to say that Mr. Osborne will put in a brief written submission saying why not, if there are any matters of disagreement, and I will decide on the papers. Let you decide which way you want to go there. But if we need to meet again, we will meet again just as soon as it can be done. I am conscious of Mr. Osborne not being in the country, and we've got to work around that.
Thank you for that. I appreciate it.
All right.
Well, I'm very grateful. And Your Honour, there was one last point that my learned friend didn't address, which was this Part 19 request that we made in September, asking them to identify the forged documents. It's a matter of him whether he deals with it now, but it's a point we need to know. We can't be instructing experts on forgery for deadlines imminently without knowing which documents are alleged to be forged. So they really must tell us, and they ought to know, because they've litigated this point apparently endlessly elsewhere.
Mr. Osborne, it strikes me as a sensible thing to do. If there's going to be expert evidence on the vital forged documents, then I would have thought the experts would need to know what other documents are said to be or not said to be forged.
I hear you, Your Honour. And I think there's an outstanding RFI from both sides, so there seems to be a separate track, but we can get on with dealing with those RFIs.
Right. Well, we'll leave it with that indication on which is a fairly strong one. So if there is no agreement to it, you'll need to be very persuasive and have a fireproof suit. All right. Anything else, gentlemen? May I thank you both for the very practical way you dealt with this, perhaps slightly unusual, but I think productive.
Well, thank you. Likewise, thanks from us that you've taken time on a Sunday for this, so I'm very grateful.
Okay. Thank you very much. Thank you. Well, we'll all log off. Thank you, Charlotte.
Thank you. We'll see you soon.